Welcome everybody for joining us. We are just waiting for more people to enter into our webinar session and we'll get started. Thank you.
This is not working. Not working. Hello, sir. Yeah, that's kind of like I'm trying to get this. I had to go back out and in 3-4 times. It's the
Okay, welcome everyone to our Legal Matters Forum series here with the Orange County Clerk of Courts. Thank you for being patient. We had a little bit of technical difficulties getting things started, but we are here nonetheless, and we have hopefully some great information to share with you tonight. This is a legal forum. We provide these free of service to the community, and this topic tonight is this Post Moratorium Evictions Update. I'm Dane Weister, the Communications Director here at the Orange County Clerk of Courts. Thanks for joining us. Now, we all know due to COVID-19 and now with the CDC evictions moratorium, which has ended, hundreds of citizens face possible eviction, homelessness, and uncertainty in the near future. So with this free eviction update, we hope to continue to shed light on the evictions process, inform the public of their rights, and share available resources for our community. As a reminder, you will actually be able to ask questions towards the end of our webinar here tonight and our forum. You can do that through the Q&A function on your screen by simply going in there, typing in your question, and we'll go through those at the end of the webinar and go through those questions and get some answers, hopefully get some answers for you. This webinar is being recorded. It's being streamed via Facebook Live on the Orange County Clerk of Courts Facebook page, and will be posted on our social media channels after this broadcast. And now, without further ado, I'd like to introduce to you your Orange County Clerk of Courts, Tiffany Moore Russell. Tiffany.
Thank you, Dane, and hello, everyone. Thank you all so much for being here today. We know this is a timely and critical topic to discuss in today's environment. This webinar discussion will take an in-depth look at the evictions process and help provide you with information regarding your legal rights. One of my office's strategic outreach goals is access to justice. So Legal Matters was created as a service for the public to make legal information easier to understand and more accessible to the public. These forums are designed to give our citizens more access to justice and give them more information they have the right to know. So our virtual Legal Matters webinars have created new opportunities for us to bring to you an innovative way to communicate. So I want to take the time and acknowledge my staff who have worked very hard to bring this webinar to fruition, as well as acknowledge our panelists who are here with us today. From my office, General Counsel, Attorney Roberta Walton. From the Legal Aid Society of the Orange County Bar Association, Attorney Camilo Parra. From Orange County Government, Diane Arnold. From Court Administration, one of our great judges, the Honorable Judge Eric Dubois. And last, we have Law Enforcement Representative Sergeant Mark Garcia and Corporal Mike Rowland. Right now, you will hear from Attorney Roberta Walton, who is our General Counsel. She will talk to you today about my office's role in the evictions process. So again, thank you for joining us this evening, and I hope you leave with additional information that leaves you more knowledgeable. So now, Roberta, I will hand the program over to you.
Well, she's trying to pull up her PowerPoint presentation, and Roberta, you want to make sure you're unmuted before you begin. Thank you.
Yes. Okay. I can't see whether or not you can see the PowerPoint presentation. Can somebody share?
Yes, we can see it.
All right.
Right.
So we are in business. So good evening, everyone. And thank you so much, Clerk Russell, for that wonderful introduction. I too would like to thank the staff for their hard work to put this together. This is some great information, and certainly my counterparts, they also have some great information to share. So without further ado, I'm going to go ahead and get started. And what we're talking about tonight really and truly is an eviction. And I want you to know that my presentation is going to be slightly slanted towards landlords, which we see here at the Clerk of Courts in terms of our customers who come in and are interested. They own properties, they have tenants in their properties, and they're interested in what are the steps and what does it mean to evict someone. So an eviction is really when a landlord forces a tenant to move out. There are several different reasons of why this could potentially happen. The one that we see the most and the most common is for lack of payment. So if the tenant has agreed to pay a certain amount to reside on the premises and gets behind and does not pay that amount, then the landlord has the right to file for an eviction. Keep in mind, in Florida, a landlord cannot evict a tenant without a court order. We do have a lot of people, and who own their property for a length of time and will come in and say, I don't care what the law says. I want them out and the property belongs to me. That is contrary to the Florida statute. If you enter into an agreement, whether written or verbal, with a tenant, turn over that premises, you may own the dwelling, but you do not have a right to possession. And in order to have that person removed, you will have to file a court filing with our office in terms of a complaint for possession, which is inevitably an eviction complaint. And so in order to obtain that order again, you must come and file that complaint for eviction with the Clerk of Courts. To legally go through the entire eviction process, you need to first, step one, you need to notice the tenant that there is a problem. So if you do not receive your payment, or if there is some other activity going on and you feel like it's in non-compliance of the rental agreement, or lastly, if the agreement that you had has tolled, meaning you entered into a 12-month agreement for the person to stay there, 12 months have tolled, and now you want them to leave. You do need to send that individual a notice. If we are talking about non-payment, that notice is a 3-day notice. If we are talking about the fact that you want that person gone because it has tolled, that will depend on the language in the agreement, or it will default to what the Florida statute says, which is usually 15 days. Or if it's for a non-compliance violation, that notice needs to be at least a 7-day notice to the tenant. Then you will come, once that notice has been delivered, and it can be hand delivered or posted to the door of that tenant, you will then need to allow whatever that time period to lapse make sure you keep a copy of that notice, because should you have to move forward and file for an eviction with our office, then you are going to need to attach a copy of that notice with it. Once you've completed the paperwork, file the notice as an attachment, share it, and you're shared in the paperwork exactly under what pretense you're trying to have the person removed or the tenant removed. All of that paperwork can be filed with the Orange County Clerk of Courts office. Then after we process that paperwork, it really goes to one of our stakeholders here on this call, and you will hear from them to talk about the process, namely Judge Eric Dubois, because they're up next. So the judge then reviews that paperwork, or should I say the court reviews that paperwork to determine what happens next. Thereafter, another stakeholder kicks in, and that would be the sheriff's office. You will also hear from them a little bit later, talking about the writ of possession process. Here's the paperwork that we have and we provide here in our offices here at Orange County Clerk of Courts. Our civil division, where most of our residential evictions are processed out of, is in room 350 on the 3rd floor here at the Orange County Courthouse, or one of our branch offices. We have a branch office in Apopka, in Ocoee, and in Winter Park. Each one of these offices can accept the eviction paperwork and offer these forms for sale if you are interested in filing for an eviction. Here, you see all of the details, all of the instructions that are needed right on the cover page, and all of the ancillary forms are attached. It does come in the form of a packet. Here is just giving you really and truly a breakdown of the eviction process. Again, what's controlling when it comes to the residential eviction process is Florida Statute Chapter 83. If you are interested or you are trying to get someone removed from your home, I will tell you, please become familiar with Chapter 83. There is a step-by-step process in the Florida statute. Kudos to our legislators, because it really does lay out exactly what's needed in terms of the entire process. Here is really a flow chart of where does it go next? And we've talked about once you have the notice and then you get ready to actually file the complaint, it goes to either the judiciary. From the judiciary, my office, once a judgment is actually entered, a final judgment in the matter, or a default judgment in the matter, then you can come back to our office to have a writ of possession issued. Now, we issue the writs of possession, but the Orange County Sheriff's Office serves them. So that would be who would initiate it on the actual tenant at the tenant's residence. In terms of the payment, we issue the writs of possession, just as we issue a summons that actually, when you initially file the eviction pleading, the payment for the summons is $10. That comes to the clerk's office. But the payment for the writ of possession goes to the Orange County Sheriff's Office. Here, we talked a little bit about those notices. 3-day notice, that is the notice for non-payment of rent. The 7-day notice that is required to be served upon a tenant is for a non-compliance of the rental agreement. So if the tenant is doing something that is against, or in your opinion, in non-compliance of the agreement, if all of the stipulations that are agreed upon and the clauses that are agreed upon within either the oral or the written agreement, then you have an opportunity to file for a 7-day notice. And when I say file, I mean serve that notice. That is a handwritten notice that you provide. I mean, we do offer templates for that in our forms packet, but you will provide that directly to the tenant, allow the 7 days to lapse, just as you would for non-payment, and then take a copy of that notice, with you down to file for an eviction if you're interested. The 15-day notice is typically once the rental agreement has told. So if you are trying to terminate tenancy, you no longer want to rent to that person, you don't have an interest in renewing the current agreement, the statutory default is 15 days unless your rental agreement says something else. Really and truly, this is just giving you explicitly the steps from the 3-day notice to coming down with a copy of that notice to file for the eviction, to have a summons issued. Anytime you start an official lawsuit, a summons is typically issued for you to have that served on the other party. This is very important in terms of a residential eviction. If it is your intent only, I just want that person out. I don't care about the money. It's a loss. I really just want that person gone. Then you can either have this summons and the complaint served by the sheriff's office, or you can actually have it posted. And so you come down with the sheriff's office, have it posted on the door, and they will have 5 days to respond. However, if you say, no, they owe me money, they haven't paid rent in several months, not only do I want them gone, but I want my money, I want my damages, then, and it's a different scenario, because now they have 20 days to respond. And when you have that summons and that complaint served on that tenant, personal service must occur. It cannot be posted to the door. It must be served to the intended party. Here, and I'm not going to belabor and go into what is required by the tenant once they've been served with an official eviction complaint and a summons, because my counterpart from legal aid is going to really address the tenant side. But I will tell you, there is a requirement, tenants, if you're out there listening, for you to respond if you're ever served with an eviction summons and an eviction complaint, and to respond timely. And so you'll hear a little bit more about that from Camilo, but we also here at the Clerk of Court operate the court registry. So not only are we the official record keeper and we process the cases, but we're also the official cashier for the courts. So if there are monies in dispute, meaning monies owed, and you agree on, yeah, you know, I haven't paid rent in 6 months. To move forward, typically you do need to post that money into the court registry to show the courts of your intent to pay the rent that is due. And then thereafter, it's when the courts get involved to determine a judgment and the direction or the course of action with the finality of the complaint, and whether or not a writ of possession is going to execute. And if that writ of possession executes via a final judgment that comes to our office, that gives the clerk's office the right and clears us to go ahead and issue that writ of possession for the customer, i.e. the landlord, to then take it down to the sheriff's office. Luckily, we're neighbors, so the sheriff's office is located on the 2nd floor here at the downtown courthouse, but you'll hear a little bit more from Sergeant Garcia shortly relative to that. Here are the fees. The filing fees are paid to us at the time that you are to file a case. If you're interested in filing for an eviction, the filing fee to do so is $185. This is a county court proceeding. So again, these transactions can be filed here within our civil division or our self-help center. Our Clerk Russell, when she came into the seat, she started something that is absolutely phenomenal here, which is our Orange County Self-Help Center. I'm going to show you a little bit about that on the next screen, but residential evictions can be processed at the self-help center as well. The filing fee again is $185. The filing fee to have a summons issued is $10. The writ of possession fee that we talked about is $90. And also to have the summons served, and I don't see that here, I think I left that off, is $40. So the $10 comes to us to have the summons issued. But in order to have that served by the Orange County Sheriff's Office, it is a $40 fee. And that fee is paid directly to the Sheriff's Office here in Orange County. In order to deposit monies into the official court registry, i.e. we talked about those monies that may be in dispute, there is a 3% fee on the first $500 and then a 1.5% of the total amount of the remaining balance. Uh-oh, I think I went too far. Did I go back? Well, I'll just stop here. So again, I talked to you a little bit about our self-help center. So here, our self-help center is actually located on the 3rd floor as well. How convenient is that? In room 340 at the Orange County Courthouse. The hours are from 7:30 a.m. to 4 o'clock. And so are the hours in our civil division if you're interested in filing there. Both areas offer the forms and our branch offices offer the forms in Winter Park, Apopka, and Ocoee. If you don't know how to proceed on your own and you're not interested in hiring an attorney or don't have the wherewithal to hire an attorney, we do offer virtual attorney consultations in our self-help center to assist you or direct you and provide you with the guidance and counsel needed to represent yourself in court. So Mondays, Tuesdays, Wednesdays, and Fridays from 8 a.m. to 4 p.m., we offer virtual attorney appointments through our self-help center. This is a partnership with the Orange County Bar Association, so you will meet with a licensed Orange County Bar member, and that person will really provide you the guidance needed on and share with you everything you need to represent yourself in court. Thereafter, the 5 deputy clerks in the self-help center or the experienced clerks in the civil division can assist you with filing the necessary paperwork needed. So if you're interested in a virtual attorney appointment, please go online. You can schedule that online. Those appointments are $1 a minute. And the appointments are scheduled in 15-minute increments, 15 minutes, 30 minutes, 45 minutes, and 60 minutes across the board. We would love to have you. And I hope this was helpful for an individual who is seeking to have a tenant evicted. If you have someone that you like removed from your premises or the dwelling unit that you own, these are really the directions and the guide to how to get it done. All right.
Thank you, Roberta.
Thank
Roberta
you. Let me stop
Walton,
sharing.
who's our Chief Legal Counsel here at the Orange County Clerk of Courts, has also been managing our self-help center over the years. So of course, also good information there to help tenants who are going through this scenario as well. So if you'd like to know more about the self-help center here at the Clerk of Courts, you can always visit our website, myorangeclerk.com, to set up those appointments with an attorney. I want to tell the community, Clerk Russell saw the need for this self-help center, knowing many people don't have the means to afford an attorney. So $1 a minute, 30 minutes, $30 to have an attorney consultation is definitely a good service to the community. So up next, we have attorney Camilo Parra with the Legal Aid Society of Orange County Bar Association Housing Division, who is going to share some information with you basically through legal aid. Thank you, Attorney Parra, for joining us.
Thank you for having me. Good evening, everyone. So I'm going to address more from a tenant's point of view. This information will benefit landlords as well. So I hope everyone will listen, and I hope that you take away something important today. So as we all know, we no longer have any protections as far as the CDC order that was temporarily halting evictions. It's no longer enforceable. You cannot rely on this to stay in eviction. Any cases that were previously stayed should be moving forward sooner or later. Tenants, please be aware that in Florida, evictions are very fast. It's been a while since they've moved this quickly, so please be aware. It is a fast process that you have to be engaged in, you have to pay close attention to, and if you ignore it, that might be the fastest way to get evicted. So two phone numbers I want everyone to be aware of. First, the Legal Aid Society of the Orange County Bar Association. My organization, we assist individuals who are unable to afford an attorney at the very least, we would like to talk to you about your situation and see if we can give you a consult. In some situations, we could even be able to represent you, but that is not a guarantee. And as you can imagine, there's a high volume of demands for assistance right now. Another resource here is the Community Legal Services of Mid-Florida. They are a sister legal aid organization that also assists people who are unable to afford an attorney. Now, let's just jump right into something that will benefit both landlords and tenants. Under Florida law, and Roberta, she spoke about this earlier, you're not supposed to take an eviction into your own hands. A landlord is not supposed to, outside of the court procedure that is prescribed under Chapter 83.56, they're not supposed to take the matter into their own hands and try to remove a tenant. There's a list of things that should not be done. One, a landlord should not indirectly or directly be interrupting any utility services furnished to the tenant. And this is whether or not the landlord is actually in control of the utility service or is responsible for the payment. Another thing landlords should not be doing is preventing tenants reasonable access to the unit by any means. They should not be removing outdoor locks. They should not be removing doors, the roof, the walls, or anything that is exterior for the purpose, unless it's for the purpose of maintenance or repair or replacement. They should also not be removing tenants' personal belongings from a dwelling unless it is after a proper surrender, abandonment, or recovery of possession or death of the last remaining tenant, or after a lawful eviction that went through the courts. Now, here's where there's teeth to this law, and this is why landlords really should pay attention here. If you engage in this conduct, each individual violation could result in your liability to the tenant equal to the consequential and actual damages, which what that really means is whatever they lost out on due to the conduct. That could include attorney's fees, could include court costs, or 3 months rent, whichever is higher. And that's for each individual violation. So please, landlords, don't put yourself in this position. Please use the court process prescribed, because otherwise you could end up with a lawsuit on your hands. So what are some reasons that a lease can be terminated? There's various. We won't be able to cover all of them, but here's a brief breakdown. So one pretty obvious one, violation of Florida laws. Usually we're talking about laws that are related to public safety or the safety of other residents. If you're engaging in criminal conduct, you could get evicted for it. Another common example, violation of a community rule. Let's say you live in a place where there's like a HOA community or a homeowners association or a condominium association. Those rules that apply to that community, violation of those rules can lead to an eviction. Violation of lease term. Let's say you have a lease that specifically says you're not allowed to have unauthorized guests overnight. If you want to have a guest overnight, you got to get permission. Some leases say that or have other sorts of requirements or restrictions. If you violate your lease, you could end up getting evicted for it. So please be careful, tenants. Read your leases. Understand what are you allowed and not allowed to do. The most common, especially throughout the pandemic, the non-payment of rent. That's what we'll be talking about predominantly today, though I will try to touch on these other areas briefly. The last and perhaps the second most common, at least throughout the pandemic, has been the expiration of a lease or the non-renewal of a lease. And we'll touch that a little more. We'll try to go into that a little bit more later. So the first step, and so let's say you're a tenant and you get one of these notices. These are the first step to an eviction. This is what the landlord needs to do before they even get the courts involved. The first two notices, these 7-day notices, Think of them as there's two kinds of them. There's a with opportunity to cure, meaning you can fix it and hopefully get to stay. There's another kind, however, without opportunity to cure, meaning they're not giving you a chance to fix it. Whatever it was so severe that you're getting your tenancy terminated, and now you actually need to vacate. So if you end up getting a 7-day notice with opportunity to cure, common example might be, hey, we found out you have a pet that is unauthorized under your lease. Please either follow the instructions on your lease on how to properly authorize this pet, or remove the pet, or you're going to need to move out at the end of the 7-day period, because if you can't comply with the lease agreement, we're not going to keep you here. 7-day notice with opportunity to cure. Figure out, what do I need to fix? How can I correct this non-compliance? Correct it within those 7 days, and that should prevent an eviction from being filed. If you don't correct it within 7 days, an eviction could be filed against you. 7-day notice without opportunity to cure. This is for a more serious violation. This often could be something like committing a crime or getting into an altercation, some sort of violent act, something so serious that the landlord does not need to give you a second chance. They should be able to evict you. This is a 7-day notice to vacate. You're not getting an opportunity to correct it. Now, the notice that we're going to talk about most in depth today is the 3-day notice of non-payment. This is the landlord telling you you're late on the rent. You got 3 business days. In these 3 business days, you really only got 2 options to avoid an eviction being filed. I guess 3 options. The first option, pay what you owe, but that means all of it. If you don't pay it in full, that doesn't correct the problem. They can accept your partial payment, give you a new 3-day notice, the clock starts ticking again. Another option, vacate the property. I understand for most of us that is not a viable option right now. Housing is difficult right now. So what's the last option? Ask very nicely for extra time. Let your landlord know what you're doing to try to get this payment current, and ask them to please not file this eviction after the 3-day period. Ask for an extension. But know that after that 3-day period has passed, if you've received a 3-day notice and you haven't gotten one of those 3 things accomplished, they could very well file that eviction. The last notice we're going to talk about here is the notice of non-renewal. Some might know it as a termination of your month-to-month tenancy. This is most frequently occurring where a tenant doesn't have a lease. A lot of tenants in Orange County do not have leases. It's all verbal. Because they pay their rent monthly for the most part, they have to receive a 15-day notice of non-renewal from their landlord, telling them, hey, this is the last month, we're not renewing, you gotta be out at the end of the month or we can file the eviction. Now, I do want to clarify something about this 15-day notice. It is often misunderstood. The 15 days have to be before the end of the current rental period for it to be proper. So I'll give you an example. There's 30 days in a month, and you give someone a notice, a 15-day notice on the 16th day of the month, saying you got to be out by the end of this current month that is only 30 days long, too late. It is not a proper termination of this tenancy because you did not give them the full 15 days. However, if you give them that same notice on the 14th day and you're actually giving them 15, 16 days to move out, that could be proper unless you have a lease agreement like Roberta had mentioned earlier that specifically assigns you an additional amount of notice. So in short, read your lease agreements, understand what you can and can't do, and understand how your lease ends. Now, this is something that is very much overlooked by the general public. There is an immediate impact on an eviction being filed against you as a tenant. What I like to say, because it clicks with people, is filed is forever. If you get an eviction filed against you, as soon as that thing is filed, it becomes public record. We don't have any form in Florida at this time. We don't have any way, any mechanism, any law that allows us to expunge or seal an eviction record. So once it's out there, win or lose, good or bad, evicted or not evicted, it's on your record permanently and functions as a blemish that will lead to, in short, just worse deals. You might get your application for a new rental place rejected outright. They might take your money and tell you, sorry, we cannot accept you as a renter because you got this on your record. Maybe you won't get rejected, but you might end up with worse deals. Like I said, you might get a higher security deposit. You might be charged some non-refundable fee. They're not charging anybody else. Your rent might be higher. What I'm getting at is, if there's a way for you to prevent this thing from being filed in the first place, that should be your priority. I have heard countless times tenants say, if they want me out, they got to evict me. They got to use the courts. That is the wrong mentality, guys. If you put yourself in that position, you're setting yourself up for a permanent blemish on your rental history. You may not have access to affordable housing anymore. So please, if you can avoid it being filed, that's your priority. So now let's talk about the responsibility that a tenant has upon being served with an eviction complaint. Remember, we mentioned earlier, evictions are fast in Florida. You only have 5 business days from the day you get served with the eviction complaint to do 2 things. First, you gotta file an answer. If you fail to file an answer, if you just let it go, if you just ignore it, you lose by default. The law is very strict. You simply lose. The second requirement is pretty tough, and a lot of people may not have a way to deal with that second requirement. The first one, sure, anyone can file an answer, but here's the second requirement. We have a court registry requirement in Florida, where if someone is trying to evict you for the non-payment of rent, in order to get a hearing, just to be heard, to fight this thing, you got to come up with the money within 5 business days. If you can't, you may very well lose the case just because you don't have the money. Now, there is a third option, and it's a little complicated. We're going to try to keep it simple. We're going to try to go through it. Bottom line, let's say you receive a complaint and the amount that it's saying you owe is wrong. You do not agree with it. You have a dispute. You can still, within the 5 business days, along with your answer, within these 5 business days, instead of depositing into the court registry, you could file a motion to determine rent. You're telling the court, look, I disagree with my landlord. That's not what I owe. Here's my proof of how much I owe. That will get you a hearing if you properly do it within time and schedule the hearing. Don't forget, you can't just file something and then just imagine things will magically happen. You got to actually schedule this hearing with the clerk of court. You will have a rent determination hearing to figure out how much is actually owed. Now, here's a note, a timely note of something that everyone should be doing. If you're facing an eviction for the non-payment of rent and you have a pending rental assistance application, you really should be proving it in your court case. You should be filing it along with your answer, proof that you have a pending application. And I would hope that you've also let your landlord know long ago that that's going on, in the hopes that maybe they won't file this thing in the first place. Now, this whole list of obligations is purely for the possessions portion of an eviction, meaning where the landlord is saying, hey, I want to possess my property again. I need to get possession back from you. It's a little different if the landlord is also suing you for the money, the damages. When you hear damages in law, I don't want you to think about what's broken. Think about money. You have to file an answer to the damages portion of the complaint within 20 days. So it's not the 5-day answer period. There is no deposit requirement to defend against this part of the eviction. But if someone files both at the same time, your answer for the possession portion is still due within 5 business days. Please comply with that. Now, there's nothing wrong with filing an answer to both at the same time. Just to make it simple for the judges and for the clerk of court to understand what you're doing, please clarify that you're answering count 1 possession, count 2 for damages. Now, we'll talk about the motion to determine rent. If there's an actual dispute, you don't agree with the amount they say you owe, still file your answer within the 5 business days. If you can, in good faith, you should deposit whatever it is you don't dispute. If your landlord says you owe $800 and you know you really owe $300, you really should deposit that 300 if you want to, in good faith, show that there's a dispute. Also attach your evidence of why there's a dispute, why you disagree with the amount alleged due, and file your motion to determine rent and schedule a hearing where you can then determine how much is it that you need to deposit to get to that next hearing. So hear me out. This rent determination hearing is not about, do I get evicted or do I not get evicted? Why should I not be evicted? This rent determination hearing is to determine how much money do you need to deposit and when, in order for you to continue the case and get a hearing down the road on the merits of the eviction itself. So now let's get into the court registry. This part it's kind of tough for a lot of us right now. If someone is trying to evict you for the non-payment of rent and your defense is anything other than, hey, I've actually paid. I don't know what this landlord's talking about. I paid, I can prove it. Here's my receipts. Unless that's your defense, you got to deposit into the court registry to fight the eviction. If you do not make a deposit, you're not complying with the court registry requirement. The laws are pretty strict. You're not even supposed to receive mediation or a court date until you've complied with this. There's an additional requirement. It's not just the initial deposit for the non-payment case. If you have a case pending, and during the pendency of the case, your rent becomes due again, you're supposed to deposit it into the court registry. Once that case is opened, you're not supposed to be paying rent to the landlord anymore. It goes into the court registry while the case is pending. Now, when is it due into the court registry? What your lease says. If you're late, if you fail to make these ongoing deposits during the pendency of your case, in theory, you could be defaulted. You could lose the case for that. So this court registry requirement, to pay or not to pay, it is a really tough subject. There's not one good answer for everyone. This is a case-by-case thing. Ultimately, it's the tenant's choice. But tenants should be aware that even if you pay, if you come up with all the money, you beg, plead, and borrow, you put it into the court registry, it does not guarantee, once that case is opened, provided the landlord's follow the proper procedure, it does not guarantee that you will save your tenancy. It does not guarantee that you will get to stay. Because being late on your rent in Florida is grounds for the termination of your tenancy. Now, if you comply with the court registry and you file your answer on time, you'll get a day in court. You'll get a hearing to explain to the judge why it is that you shouldn't be evicted. But honestly, guys, if you know it in your heart's heart, if you know based on your relationship with the landlord and your communications with them that they really want you out, this isn't that much about the money at this point, you may need that money to move. Don't throw the money into the registry if you're just going to end up homeless and without any money to move. That's really what I'm getting at here. So ideally, in a perfect world, tenants would be using their rental assistance funds to deposit into the court registry. That's not possible most of the time. These rental assistance funds could take weeks, if not months, to process, and we only got that 5-day answer period. Having said all of this, a lot of landlords are happy to take full payment and dismiss the case. A lot of landlords, if you're willing to put it in writing, that you're going to go on a payment plan with them to get caught up in the rent, in addition to your monthly payments that you already owe, a lot of landlords are happy to let you enter that sort of an agreement. But make sure you get these sort of agreements in writing. Make sure they're signed by you and your landlord. And it does not hurt. In fact, I highly encourage that you file it in your court case. Let the judge, let the courts know that this is what's going on. Even if your landlord's not cooperating, even if your landlord, let's say, is not allowing or is not willing to participate in rental assistance programs, because a lot of them require you you got to apply, your landlord also has to apply. Even in that case, you should still be trying to get that rental assistance and you should still be trying to get it to your landlord. Why? Because at the very least, you might be mitigating the debt. You still owe this rent. You want to at least lower the amount of debt that you're going to be in for not paying the rent that you were contractually obligated to pay. Now, one more reminder, if you've got a pending rental assistance application, please let the courts know. Include that in your answer, proof of this. And of course, keep your landlord in the loop as to the dependency of any ongoing or of any pending rental assistance applications. Last year, I got a list of resources, but I'm pretty sure everyone else here on this panel is going to have even more resources for you guys and gals. So I hope that gave you guys some valuable information. In short, communicate with your landlords, be compassionate with one another. And if all else fails, try to reach out to a local legal aid organization. Hopefully we'll be able to help you out.
Great. Thank you, Attorney Camilo Parra. So I have you. I usually wait to get to questions at the end of our legal forum, but we have a question that was directly related to some of what you were sharing. So I want to share this question with you. This question is, can a tenant serve the landlord a 7-day notice to cure if they fail to address certain reported issues?
What you're describing is a rent withholding. We'll go into it, but before I go into it, I want to give this disclaimer. In the history of rent withholdings, in the history of cases I've had where I'm assisting a tenant with a rent withholding, I have never instructed a tenant to actually withhold the rent. Sure, I've told tenants, send the letter, make the threat, but when push comes to shove, if your choice is risk having an eviction on your record, where sure, you'll have a defense, you might very well win, maybe you won't get evicted, but you're still stuck with that eviction on your record for the rest of your life, I just don't think it's often not a good move. So let's talk about what an actual rent withholding is. If your landlord is not complying with a material term of your lease. So another way to put it is, if there's something really bad on your property, like it's maybe a risk to your health, to your safety, something so bad that no person in their right mind would be renting this place if they knew this was wrong with the property, maybe you could do a rent withholding. You can send your landlord a letter at least 7 days before the rent is due, telling them you're not paying this rent until they make these repairs, and it's at least 7 days away from rent becoming due. If you do this, and then your landlord tries to evict you anyways, you can use it as a defense if you have proof that you've done this. But it does not change the fact that you're now stuck with an eviction on your record forever. So it is a real double-edged sword, and it is a tough situation to handle. I do encourage you, if that's what you're facing, a repairs issue, substandard conditions issue, please, before you do any rent withholding, consult an attorney. If you can't afford an attorney, there's a lot of resources we've been giving you guys. Try to speak to an attorney first, guys.
And before you go, one other question, and this actually was a question that I had in the back of my mind when you were talking about the registry. So our next question for you is, if you don't put the money in the registry because you know the landlord will do everything they can to get you out, will you still owe that money after you've been evicted? Can you be sued to get that debt paid after you've left the property?
Absolutely. Absolutely. So, and they might not even sue you. They might just treat it like any other debt. They might sell the debt to another person who will then try and collect it from you. They might forward it to a collection agency who will then be on your back about it. It could affect your credit. They could, in the same eviction action, like we were talking about earlier, be suing you at the same time for the money. So I do want to be clear. You owe the rent. You got to pay it. It is a debt. A debt is a debt is a debt. What I'm getting at is, if you desperately need that money to move, it may not be wise to deposit into the registry if you know that your landlord really wants you out at the end of the day.
All right, great. Thank you. Attorney Camilo Parra with the Legal Aid Society of the Orange County Bar Association. Great information. And so we have more to come. If you're just joining us, this is the Legal Matters Forum series with the Orange County Clerk of Courts. Our topic tonight is the Post Moratorium Evictions Update, as we're trying to give you as much information as possible as the CDC moratorium has ended, and we know that evictions filings are likely going to continue, possibly increase, and then we have people facing this. This is a recorded webinar, and if you do have a question, make sure you can submit it into the Q&A portion at the bottom of your screen. Just type those questions in, and we'll get them answered throughout the forum. We also will have a survey for you to fill out at the end of the presentation, so please stand by for that. So now let's talk resources. Up next, we have Diane Arnold, who is the manager of Citizens Resources and Outreach Division at the Orange County Government, who is going to share some information with us about the rental assistance program through the county. Thank you for joining us, Diane.
Thank you. Good evening, everyone, and thank you for taking the time. We want to provide information to try to keep as many people in their homes as possible, and we do have funding to be able to do that. So I want to start by sharing some information, a little bit of background information about the funding we're using. If we could go to the next slide. So the funding we're using right now, the COVID-19 relief bill provided across the country $25 billion in emergency rental assistance. That's administered by the U.S. Treasury through the Coronavirus Relief Fund. Orange County received $33.4 million to use for emergency rent assistance to our residents who have been impacted by COVID, have suffered a loss of income or an increase in expenses due to COVID. The money can only be spent in unincorporated Orange County and smaller cities. And that's because the city of Orlando actually qualified to receive a direct allocation of their funds based on their population. So the city of Orlando received approximately $8 million for city residents only. We are working with the city of Orlando to try to coordinate our program criteria for both programs and outreach to make it as seamless as possible, with it being two different programs for the residents of Orange County. But Orange County government is providing the emergency rental assistance for all of Orange County except residents who live within the city limits of Orlando. Next slide. So as I just mentioned, Orange County residents, we just keep emphasizing those within the city of Orlando because we're getting a lot of overlap. So we're trying to make sure everybody knows what program they should apply for. So some of the eligibility requirements is that the household must have been financially impacted by COVID. It doesn't mean everybody in the household had to have reduced hours or lost a job, but the household had to have been financially impacted. There is an income requirement for this program, so the household income has to be at or below 80% of the area median income. And we just put a small chart here just to give a brief example of that. So for a household of 4, at 80% of the area median income, they could make up to $61,050 and still would be qualified for this program by income. But if they were over that, we would not with this program be able to assist them. We are looking that tenant has a lease obligation on a unit. That doesn't mean it has to be a current lease. It could be a carryover month-to-month lease, but we need to know that they have a rental obligation or they had a lease obligation, and it has to be their primary residence. Because you know, a lot of people come to Florida and have homes in other places, so it does need to be their primary residence. We are looking at this time for tenants who are 1 month in arrears. And then we do require some documents to verify eligibility, residency, some of those types of things. If we could go to the next slide. So here's some of the examples of tenant documentation requirements. We need to have income documentation for all household members, but there are multiple ways that tenants or applicants can provide their income documentation. The simplest way is actually a 2020 tax return, because if a tenant provides us with a tax return, we're able to just take line 11 from the tax return that was put in the statutes by the federal government and use that as the household income, and we don't need any other documents to verify it. So a filed tax return is the simplest way and the quickest way to try to speed through the process. If they don't have that, or they're not able to provide it, they can provide us with pay stubs for the last 30 days. If they're receiving unemployment, they can provide their unemployment letter. We're also looking at if people receive benefits, if they've been approved since January 2020 for a federal income-based program such as food stamp or SNAP. If they give us that approval letter, we're also able to provide them with an attestation so they can just fill out their income and they don't have to provide income documents. It's not just food stamp, it would include the low-income home energy assistance program, school nutrition program, any of those types of programs that do household income qualification. If they've received any of those documents, they would also be able to provide that to us. We also do look at one of the other options they have given us is what they call fact-specific proxies, which means someone lives in a low-income neighborhood. So we will also check addresses for applicants, and if they're in a low-income neighborhood, we're also able to allow them just to complete an attestation document for their income instead of needing to provide other documents. So there's multiple ways that applicants can demonstrate their income to make sure they qualify for the program. We do want a late or eviction notice. It can be just the 3-day notice that just says my rent is late. If your rent's due September 1st and it's September 3rd and it's late, that's a late notice if your landlord gives it to you. If you have an eviction notice, we really want them to upload the eviction notice and put a note in there that it is an eviction notice, because we will expedite that application. As mentioned earlier, we do receive a lot of applications. So there is a process to do this and it does take time. But if we know somebody has actually had an eviction filed against them, we will expedite that application, and we will reach out to the landlord and make sure the landlord knows about the program, assure them of the benefits of the program, how much we're able to do. Because also, as mentioned earlier, a lot of times if a landlord knows they're going to get paid, they're willing to work with us. So we will immediately reach out to the landlord in those cases. If they have a current lease, or the lease, if it's expired, but it's month to month, or any other documentation that can just verify that they have a rental obligation and that it's their primary residence. That's what we're looking for. COVID-19 impact, and that can be demonstrated in a variety of ways. If somebody received pandemic unemployment, that's COVID impact, and that's all they need to show us. If they received a furlough letter, a furlough email, reduced hours letter, reduced hours email, we'll also accept those. Self-employed can give us something showing that their business was impacted. So we will take multiple types of documents. We just need to have something that verifies that there is a COVID impact. We're also doing photo IDs for just adult household members. And then for duplication of benefits, one of the things with this program, we can actually do up to 12 months of arrears, which I'll give a little bit more information on later. However, we cannot duplicate the same months of payment with any other program. And since our Florida is the state of Florida program, and they are providing assistance statewide, even if there's other local programs in the jurisdiction. So we're having to work to make sure we do not duplicate the same months. So an applicant could receive assistance from more than one program. They just can't receive them for the same month. So if you're behind in your rent for July, August, and September, you can only get from one program for July, August, and September. But then if you're late other months after that, you could still apply to a different program. But we do have to check and make sure with other programs that we're not duplicating benefits for the same month. So we may have to ask for documentation if you received assistance from other programs to make sure that we can pay for those months, so we're not duplicating the benefits. Next slide. So as I mentioned, the maximum assistance for our program per household is $20,000 at this time. And that includes, it can include arrears up to 12 months beginning April 2020. So starting with April 2020, we can pay, but we can only pay for 12 months of arrears. And we can bring that up to current. And if within that $20,000, we also can provide up to 1 month of future rent or prospective rent. And we look at perspective if you're still going to be in that unit so that we can pay for it. If, for example, your lease was expiring September 30th and we approved you this month and you weren't continuing a month-to-month tenancy, we wouldn't pay 1 month perspective for October. But if you were going to remain, then we could pay up to 1 month perspective or 1 month future rent for October, as long as it was fit within the $20,000 maximum. One of the things we did when we were developing this program that sometimes is very complicated with programs is we know what the base rent is. Let's say your base rent's $1,000 a month. But if there are a lot of required fees in there, such as a lot of landlords charge back for certain water utilities or something like that, that might be a separate charge on the lease. I mean, on the ledger, but the lease states that that will be charged, or washer dryer fees, pet fees, those type of things we are including in what we will consider rent, and we will assist with those fees as part of the rent. So if your rent's $1,000, your water's $25, your pet fees $25, your washer and dryer's $25, we would pay up to $1,075 per month to be able to cover those fees. There's only a few fees that we're not including in our payments. We are not doing late fees, return check fees, garage fees, but most other fees are being included because we do want to try to assist both the tenant and the landlord and make them as whole as possible in terms of making sure the tenant is brought current. And we do ask the landlord to, as a requirement of participating in the program, to agree to accept our payment for full payment for the months we're paying for, which means they would need to forgive any late fees or the fees that we're not paying in order to participate in the program. And most landlords, we have not had an issue with that. Most landlords have been willing to do that because we are paying enough that it's a significant amount on what people are behind in rent. Next slide. So we also, as part of this, money does come down through the federal government, through the US Treasury. So we are required to collect certain data because we're required to report on it monthly to the federal government. We do have to collect information, the number of individuals in the household, obviously the household income, because it is an income-based program, race, gender, ethnicity of applicant. And then we have to report out certain things separately. So we have to report the amount of rental arrears, and the way they define that, that's past due rent. And then the amount of prospective or future rent, that's reported separately because they're wanting to see how much we paid for people who were past due and how much we paid for future rent. And then also the number of months paid by the Emergency Rental Assistance Program. So if we paid 10 months of arrears for someone, they were 10 months behind, then we paid 1 month prospective, we would report 10 months for arrears, 1 month prospective, for a total of 11 months that we would pay. And that's just some of there's other information we have to report, such as zip codes and other things. But this is the kind of information, a lot of it, that we need to collect from the people who apply to the program. Next slide. So this I just put here, this is a slide. You apply for this program on Orange County's website. So you just go to Orange County's website, ocfl.net, and right on our main page, it has information for COVID-19 information resources, and you can click on rental assistance right there. And when you click on that rental assistance, it's going to take you to another page where it gives you information about the requirements, it gives you information about the documents. We have a frequently asked questions, and then we also have an address check, which we'll show you next, just to try to help between Orange County and City of Orlando. Next slide. So when you clicked on rental assistance on that page, this is one of the things that you see there. So we have the requirements, but one of the things we put on our site was an address check. So a lot of people may have their address, when they write their address, is Orlando. And so they may think, well, my address is Orlando, so that's City of Orlando, but that's not necessarily true, because there are a lot of people who have an Orlando address. that do not live within the city limits of Orlando. So we have an address check for them here to be able to check their address just to see if they meet the requirements. And that way they know they don't complete an application to us if they don't meet the requirements. We still have people that do, because sometimes the address doesn't come up, or sometimes they're not sure. And as I mentioned before, we're trying to work with the city of Orlando also to be able to make sure we coordinate as much as possible. So the city of Orlando also has an address check on their website, because their application is online also. And they have a separate address check on theirs to just try to provide that as much as possible for the applicants, so they're able to check their addresses before they move forward. And then over on the left on this page, you see kind of the table of contents over there. And this one is the address check, but any of those that an applicant or any resident click on will give them additional information. We have a whole list of frequently asked questions. We have the tenant eligibility requirements, the landlord eligibility requirements, and then the last thing you see there is apply. And when they click on that, it will take them to the application page where they can set up an account and apply. And one of the other things we did with this program is the software we're using allows the applicant to log back into the system at any time after they submit their application and be able to see what the status is of their application. And then one of the other things that we do with this program, because we want to give everyone every opportunity to be able to get assistance. If they apply and they don't provide everything that is needed, either in terms of documents, or they don't fill out all the household members or anything like that, what we do is we have the staff review the application. And after they review it, if all the information's not there or something's needed, they make both a phone call to the applicant to let them know that we do need additional information, and they let them know that they will be sending them an email with the information that's needed so that they can respond to it. We call them first because a lot of times we all know email can get lost in a bunch of emails or in a spam folder. So we want them to know that an email is coming to them so they know to be looking for it from the Orange County Rental Assistance Program. So that's just part of the process that we do with this program to make sure that we're giving every applicant every opportunity. And you'll also notice on this same page where you read landlord eligibility, we provide the same information for landlords, the eligibility criteria for them, which is much more streamlined because they're not having to income qualify and do some other things, but they do need to agree to the requirements of accepting our funds. They do need to provide us with information on their tenant, contact information, the amount they say is due from the tenant, and then also information to contact them if we need to, so that we can work with them to provide the payment for the tenant directly to the landlord, which will then assist the tenant and assist the landlord with receiving the funds. And if a tenant applies and they give us the name of their landlord, we'll reach out to the landlord. If a landlord applies for themselves and gives us the name of the tenant, we'll reach out to the tenant. So either way, a landlord or a tenant can apply, and we will reach out to the other to connect them together so that we can process it, the application for the tenant and the payment for the landlord. Next slide. So this is just a little bit of additional information we wanted to provide. So the online portal is remaining open. That's the page you just saw. So it's not opening and closing at certain times. At this point in time, we do not anticipate closing it anytime in the near future. So the online portal remains open 7 days a week, 24 hours a day. The tenant or the landlord can complete an application, as I just mentioned. Applicants are able to log back into the system and they are contacted. I put the website address there just in case anybody wants to see anything. It is ocfl.net. It is on the main page, but I gave you the / to the rental assistance. One of the other things you see there is we have for questions, please dial 311. So I know you know Orange County has a 311 system where they answer government related calls for anything, what could be trash pickup, it could be pets, anything like that. However, in this case, for emergency rental assistance, the calls that go to 311 for emergency rental assistance actually get transferred to the emergency rental assistance staff. So it's actually staff from the emergency rental assistance program that is answering the calls that come in related to emergency rental assistance. So it's not just somebody that's taking a message and then getting it back. It is actually being transferred through to us for that program. And that concludes my presentation.
Okay, thank you, Diane. We appreciate it. Good information on the rental assistance program with Orange County. Diane Arnold, who is the Manager of Citizens Resource and Outreach Division with Orange County Government. We have had a few more questions come in, but I'm going to hold those questions to the end so we can get through the rest of our presentations. So up next, we have the Honorable Judge Eric Dubois, who's taking time to share with us a perspective from the bench. Judge.
Thanks, Dan. I appreciate the opportunity and want to echo some of the sentiments that have been shared with everyone. Our role as the judge is to apply the law to each case as it comes before us. The comments that Roberta made and the comments that Camilo shared with you could not be more true. If there is no money in the registry, unfortunately, the state of Florida and the statutes require there be money in the registry. It's what we as judges call a pay-to-play state. You're not going to get a hearing. What Diane just shared with everyone about all of this money that is out there and available, I would be remiss to say if you haven't paid rent in the past few months and haven't been able to, you know that next knock on the door potentially is going to be the eviction. Don't wait for the eviction to get served on you. It may be too late. As Roberta and Camilo talked about, it's a very fast process. It's a 3-day notice to cure, and it's a 5-day notice, 5-day eviction statute. On day 6, the game could be over. Of course, if you file and you're making that request for some of this money that's coming down from Washington, let the court know. As Roberta and Camilo said to you, we can't read your mind. If we don't see it in the court file and we don't know about it, it didn't happen. So if there's an issue, my suggestion, and I can't give legal advice, and unfortunately, I'm not going to be able to answer case-specific questions. Reach out to your landlord now. Let them know, hey, this is what's going on. I'm going to apply. I just learned of all this money. I know there's a new wave of money coming from Washington. You know, can we reach some agreement where I can give you a little bit what I can do now to hold this off so we can both participate in this? You can be made whole and I can get current. I don't want to leave. My guess is, from talking to landlord and talking to attorneys for landlords, they want to work things out. I've asked and have not been told that there's been a mad rush of people to file evictions post the moratorium being terminated by the U.S. Supreme Court. But that day may be coming. This is the week, and next week, my guess would be, is when we're going to see, based on the 3-day notice and then that surge, if there's going to be one. But get ahead of it. From the judge's perspective, our hands are tied. We want to help you, but there's only so much we can do. And the advice that you're getting tonight from Camilo, from Roberta, the information Diane shared with you is all great and very useful. Of course, some judgments have been entered. Some final judgments have been entered, and we've held off on the clerk's ability to issue that writ of possession until now. And as you're going to hear from our law enforcement counterparts, you all need to pay that fee to get that eviction moving again. We're not just going to summarily have people served with their writs of possession because it's a $90 fee. So you need to come down. If you're a landlord looking how to get your case moving again, you need to come down and pay that fee. If you're a tenant and you've made some payments in between the time the final judgment was entered and now, let the court know. There may be some legal remedies that the court has to change your situation. But again, we can't read your minds. Each county civil judge right now has roughly 15 or 16,000 cases in their division. Not all are evictions. But going back and spot checking evictions is not what we have time to do and not what we do on a daily basis. So we don't know what happened unless you tell us. I'm here, we're here to help, but we're also here to follow the law as it's written. Unfortunately, the statutes haven't changed, and the statutes, the way they are now, is they were the way they were pre-pandemic. And you've got a very finite amount of time. And if there's no money in the registry, unfortunately, we're not legally allowed to set you for a hearing. So with that, Dane, I will kick it back to you and let you pass it on to the next speaker. Dane, I think you're muted. But I'm sure what you said was I was brilliant.
It was. I'm sorry, I was muted. Thanks, Judge Dubois. You were talking about eviction filings. It was actually one of the questions we received from one of our attendees about how eviction filings, what they look like number of filings since the moratorium ended. Well, it's just been 2 weeks since the moratorium ended, and I can tell you because we looked up the data here. My team looked this up, and so just for the month of September, we've had 129 eviction filings so far. So might sound like a lot. It actually is not. It's not. It does not look like it's like a huge increase in filings. In August, we had a total of 698, and back before pre-COVID, I've looked at these numbers because we've had requests for them. Many times we were in the thousands, 1,000, over 1,000 a month. So 129 so far just in the month of September, just kind of sharing some of the filing numbers we're seeing. So.
And I would just keep in mind, most people don't file the eviction until around the 15th of the month, because there is that grace period, and then it's due on the 5th, and then you got the 3 days. So next week, unfortunately, could be a bigger spike, but we're hopeful with all this money and the programs that Diane talked about and the money that the city of Orlando have, that we can divert some of that and avert some of those evictions.
Exactly. And anybody out there who needs some more information on those resources, you can go to the clerk's office website. We've got a page there that's dedicated to resources, Orange County rental assistance, City of Orlando rental assistance, even some federal assistance to help with bills. I think it's actually a state program. So take a look at myorangeclerk.com. So next in our presentation, and our final presenters, or people who are going to share information with us, they're not just people, they're law enforcement. And they're with the Sheriff's Office. We have Sergeant Mark Garcia and Corporal Mike Rowland, who have more on the serving process and what they've been seeing. Gentlemen.
Good evening. Thank you very much. Thank you, Ms. Russell. I want to thank Officer Ms. Russell for inviting the Orange County Sheriff's Office to join in the discussion. The last 18 months has been very trying on everybody who owns a stake in rentals and evictions and in the process. I'm going to strictly focus my comments towards the landlord-tenant residential evictions, not address any other type of eviction processes. For those that are not familiar, the Sheriff's Office is not at all involved in any way in the lawsuit that precipitates an eviction. The Sheriff's function is simply to execute enforceable orders issued by the court. We're mandated by law to carry out these orders. Our role is strictly ministerial, and what I mean by that is we do not take sides. We do not take the landlord side or the tenant side. We're strictly there to enforce the order. Our deputies will act on the strict language of the order, providing that as normal, it's lawful, and doesn't ask us to violate any of our agency policies. So right now I'm speaking to the landlords participating, or that are going to view this on video later. If you are renting property or rooms for rent, it is incumbent upon you to know what your responsibilities are and what is required of you prior to bringing any eviction issue to the Judicial Process Office of the Orange County Sheriff's Office. The staff in Judicial Process can only answer procedural questions regarding the service and execution of eviction-related orders. They will not provide legal advice or provide you options on what to do. That's your job. What I suggest, if you do have questions on what services or what is required of you by the Orange County Sheriff's Office, get on the web, visit ocso.com, and in the search bar at the very top of the page, just type in judicial process and hit search. The first link will take you to the page of the judicial process section. There you will see frequently asked questions and the list of fees that are going to be required of you. So when the lawsuit's complete, a judgment's been granted and an order issued, the writ of possession has been issued by the clerk. All your paperwork will come to room 240, which is on the second floor of the Orange County Courthouse. That is judicial process. Your paperwork, the information you put on the paperwork needs to be correct. Please try to avoid abbreviations, abbreviating Orlando, which is not legally correct, creating your own abbreviations. We do require exact legal addresses and legal descriptions. We do not assume who we are evicting. We need to be positive. If the property is a room or a separate structure, you can label it however you want and then just notate it on the writ. So the fee is $90 for the eviction. That is required of the landlord. It's non-refundable and it is mandated by statute, which, as Ms. Walton stated, it's in Chapter 83. Chapter 30 defines all the other fees that are required when you have paper served, such as a summons or other notices. Once the writ is taken in by my office, which is judicial process, the staff will confirm that you provided the best phone number to reach you. That's very important. This is for the deputy to schedule an appointment with you to finalize the eviction process. Please wait for the deputy's phone call and check your voicemail often. A lot of landlords see the notice that the deputies post on the tenant's door and they see that it says in bold, bright red letters, final 24-hour eviction notice. That does not mean the eviction will take place within 24 hours. It's actually just the opposite. That notice is for the tenant, notifying them that they have at least 24 hours before the eviction occurs so that they can attempt any last minute legal arguments to obtain a stay or make preparations to vacate the residence. And a final thought for the landlords before I address the tenants: you must wait for your appointment from the deputy. It's conducted on a first come, first served basis. At full staffing, in my section, we have 10 deputies servicing the entire county. Currently have 7 full-time deputies currently. But as of this afternoon, we've received, which is coming up slowly to normal levels. We have received 2,978 writ of possessions this year, 125 this week. So placing calls to my office about how long it has been since rent was collected, there's missing property or damaged property, in an attempt to speed up the eviction, it will not matter. Okay, you have legal remedies as a landlord afforded to you by Florida law to recoup those losses. My deputies not only do evictions, but serve protection orders, such as domestic violence, repeat violence, and stalking injunctions. They serve child pickup orders, mental health, and substance abuse commitment orders. These orders, as you understand, take priority over evictions just by the very nature of the order itself. There's an individual's welfare at stake. So it's imperative, and this is why it's very important for you to be reachable by the telephone number that you leave us, so that we may schedule the appointment for the eviction with you. Please be patient. We'll get to you as soon as possible. Now, as far as the tenants go, as I stated, that the sheriff has no say-so in the eviction process. When you are served, as the Judge Dubois brought up, when you're served or see the first paper posted on the property, you need to act. Waiting for the deputy to arrive and then trying to discuss the matter or showing the deputy paperwork is futile. It's too late, honestly. Any legal arguments need to be made in court. You need to have filed something with the clerk of the court. If all attempts to stop the eviction have failed, and you happen to see the deputy who's posting the 24-hour notice, or if you're able to reach the deputy by phone that posted 24-hour notice, talk to them. One variable that they do have under their control is the time within reason. If you need a few days to make arrangements to move, to get a truck, to rent a truck, you get paid at the end of the week. You have someone in your household that has special needs, tell the deputy. They can provide you with some time to allow you to move within reason. Understand the bottom line for the deputy is that they're obligated to serve the order, to carry out the order. For everyone involved in this process, landlords and tenants, understand that the sheriff is obligated to ensure the rights of all parties involved. We're there to protect everyone's rights. We're morally and statutorily obligated and bound to ensure the safety of all residents and visitors that are within Orange County. This includes landlords and tenants. Sometimes the obligation may momentarily conflict with someone's personal desires or their needs to carry out something, but we will do the best we can to satisfy the order and to ensure everything's performed in the best interest of all parties involved. The deputies that work for me, they're a diverse group, they're a compassionate group, they're an experienced group. All of them are issued a handbook that contains all of the social services offered by Orange County, services that assist families, veterans, youths, individuals that need assistance with pets, the whole list, etc. The deputies can only offer or refer you to assistance, as I stated. Unfortunately, by the time the deputy is speaking to you, it is generally too late, and they are bound to carry out the order of the court. And that's pretty much in a nutshell, straightforward. That's the sheriff's office involvement. Thank you for the time. And any questions? I'll prepare for any questions, I guess. I think you're muted.
Thank you. I was muted. Thank you, Sergeant Mark Garcia and Corporal Mike Rowland. Corporal, do you have something else you want to share?
Good evening, Corporal Rowland, Sheriff's Office. Again, thank you for inviting us this evening and providing this information to the county. I just want to reiterate what Sergeant Garcia stated. When our deputies from the Enforceable Writs section post a 24-hour notice, we're simply complying with an official court order to do so. In conjunction, when we return after time has elapsed to execute the order, please understand we understand it's a stressful situation and we are empathetic, but we still need to comply with the order that was given. We'll simply ask you to quickly grab, your immediate stuff, wallet, purse, stuff like that, medication that you carry with you. And as Sarge says, other arrangements for other property could be made at a later time. As this time would probably not be the best time to dispute that because the order is still there and we have to carry out the order. If you have any further assistance, I would refer back to that help site for further references. And I appreciate your time and thank you.
Yeah, thank you. 311 is definitely one of the lines that can help with information. But for you all, Sergeant, and we're going to get to our question portion, but Sergeant or Corporal Rowland, what has it been like for you all? Have you all already seen an increase in your activity as far as serving, or has it still been pretty much what it's been like over the last couple of months? As we said earlier, the filings here at the Clerk of Courts have not really gone up by a large amount. How has activity been for you all related to this?
It has not been overwhelming. We are slowly approaching our normal numbers. I think at the pace we're going, by the end of the year, we'll be close to our normal yearly average, around 5,000 to 6,000. The bulk of the increase has been the alias writs that we've seen this last 2 weeks, just basically the writs that were initially denied. they're being reissued and brought down to our office. Not a whole lot of new filings.
Okay, great, thank you. So good information there. So let's get to some of the questions we have. And if you do have a question, remember that you can type it into the Q&A function as you see at the bottom of your screen. And again, we'll get to your questions. So we've had a few questions that have come in, and our panelists have even typed in some answers, but we like to verbally talk through these questions since not everybody can see the answer. So one of the questions we had for that Roberta Walton helped, our attorney Roberta Walton helped answer, was if your name is not on the lease agreement, can you provide a defense to an eviction? Roberta, if you're still with us, you want to share your answer with that? Again,
Yeah. Actually, what I said, Dane, was you can still respond to the complaint as an interested party. However, if you lack standing, and when I say standing, I mean you don't have a contractual agreement between yourself and the owner of the property. Your name's not on the lease agreement. You did not contractually obligate yourself to be there. Then you may not have any rights to possess the property. So you really may not have standing, but if you want to go on the record and share something with the court, you can certainly do so as an interested party.
okay. One of our other questions was, and is, the lease agreement with the tenant was a month to month. So this is from a landlord. His lease agreement or her lease agreement with the tenant was month to month. I notified the tenant via certified mail in the month of March that the lease was ending in the month of July. Tenant failed to vacate the premises, so I filed for an eviction. The tenant responds in 5 days with a copy of a check for rent month of June and July. How long do I have to wait to hear a response from a judge?
And so, what I explained to this attendee is it sounds like he's now dealing with a holdover tenant situation. Sounds like there was a certain notice requirement that was placed into the original agreement, the original tenant agreement, of which he sounds like he complied with back in March to let the tenant know in advance that he did not have the intent to renew the lease agreement. Well, the tenant decided not to move out. And so what we call those people are holdover tenants. If there's no language, as I said earlier, in the initial lease agreement relevant to holdover tenants, then it's going to default to the statutory language that's in Florida statute section 83. And basically what he would do then is it's a 15-day period. So he would now need to, after the tenant held over, he would need to serve the tenant with a 15-day notice. Allow that 15-day period to toll, and letting the tenant know that he didn't intend to renew and would like for him to leave. And once those 15 days have tolled, and this is considering if he's paying, because it sounds like he has some checks, and so I'm not dealing with all the facts here, then he can then take a copy of that notice and file for an eviction, as we talked about. And we certainly, both Camilla and I have gone through the steps that he would need to go through to file for an eviction. The only difference would be to determine whether or not there is money owed. If he's not trying to dispute any money, no damages, he just wants possession to be relinquished of the property, then it's going to go through the process, and it's going to go through as a summary proceeding in terms of the 5-day notice. Well, once he does the 15 days, then the tenant will have 5 days to respond if he just wants possession back.
Okay, great. Another question we received, if a tenant has already received a 3-day notice for an eviction, can it be substituted for a normal eviction?
And I think that was me as well. And I said, it's not, I think, the terminology was a little off. It's not so much a substitution. If the tenant has been served with a 3-day notice, that sounds like that's step one of the eviction process. So we've gone through all of the steps of the process. So a 3-day notice, I'm going to make an assumption that there's a non-payment of rent issue, because that's the notice that is aligned with non-payment. And if that is the case, then that 3-day notice, once those 3 days told, if there hasn't been a cure, i.e. there has been no rent remitted or the amount in dispute remitted to the landlord, then the landlord has every right to go down to the courthouse and go to step number 2, which is to file for a complaint for an eviction and have a summons issued.
Okay, thank you, Roberta. Another question we received was, can you appeal a final judgment? And Attorney Camillo, you answered that one, saying any final judgment is appealable. But my follow-up question to that one would be, how does somebody go about appealing? If someone can share, you file an appeal, right? But how do they go about that?
Camillo, you want to answer that?
Could you jump on that one? I'm so sorry.
Okay, no, that's fine. So if it is the intent, meaning you don't agree with the final judgment, certainly you can file an appeal. The eviction is a county court matter, so it will be heard at the circuit court level. If you're going to, no, I think oh yeah, it's appealable, DCA. Now, I do want to throw something in there, because Camillo said appeal. If you feel like something happened or there was a defense that did not get shared and the final judgment was entered, then there's also, within a certain amount of time, there's an opportunity to file a motion to have the final judgment set aside. So I'm not sure if the person was trying to ask about the appeal, Camillo, or were they asking, could you have the judgment set aside and for an opportunity to go back and be heard by the court? Those are a couple of different ways to do it. But if you want to file an appeal, you can come down to the second floor, not the third, but the second floor here at the courthouse in room 210, and they will accept your appeal.
Let me just add in there though, if someone is contemplating an appeal, they need to make sure that they follow the rules of civil procedure to a T. Because if you don't ask for certain things like Roberta was asking for, like the motion for a rehearing or reconsideration, or and asking the trial court level judge to reconsider their decision, the appellate court may kick it out as it not being ripe or not being ready for an appeal, because you haven't exhausted all of your remedies at the trial court level. And keep in mind that will happen very quickly from the 5th District Court of Appeal in Daytona, because they are now getting every appeal from county court, and they will clean out the ones that aren't ready. So, and you also need to provide typically a transcript of the court proceeding. And if you don't go with a court reporter, it's going to be very hard to establish your transcript and establish a record of what occurred. And getting a transcript is costly, which is why I think someone like Roberta in the self-help center, or what Camillo is saying with contacting an attorney from the onset, would be critical, because there's certain steps and certain things that lawyers are trained in knowing and doing that someone who's not trained in that, the slightest mistake can have long-term consequences on you that you'll never be able to recover from.
Judge Dubois is absolutely correct. The first, and that's the reason why I'm saying I know that they use the term appeal, Camillo, but I was thinking they might be talking about asking for another hearing, or asking to set aside because there's some other evidence or something. But again, if you're going to do that, if you're going to file the motion, you go back to the 3rd floor here exactly where you filed the initial complaint or responded to the initial complaint and file that motion. But you do have a set time period to do that. If you're going to do an appeal, Judge Dubois had a very great point. That means that the initial hearing where the final judgment was entered, that you would have to account for that proceeding. And that would mean that you would have hired a court reporter, because again, it would be on you to make sure that that expense is accounted for, not the courts. And yes, there are trial clerks that the clerk's office provides in the courtroom, but that is not an official transcript or an official record.
Okay, thank you, Roberta Walton and Judge Dubois. A lot of different parts and pieces to these questions like this. So we have a couple more questions. If anybody else on our forum has a question, make sure you type it into the Q&A function at the bottom of your screen, and we'll try to get it answered. So next question we have is from, or this is actually for Diane. And the question is, why do they need to upload the entire lease document? We've found that some leases are 20 to 30 pages, and that has been very cumbersome to upload related to the rental assistance. Diane?
So they don't totally have to upload the entire lease document. We actually started out with only asking for specific pages, but because leases are so different, there was no way for us to know which page it was. The most important information we're interested in is the pages that list the rent amount, because that's something we have to verify. The household members, because that's another requirement that we have to verify. And then also the landlord information, so we can verify it. And just so you know, as I mentioned with other things, if somebody doesn't upload the entire lease or they don't upload the relevant pages, again, when our staff reviews that application, they will let them know what they need. And if we can get the relevant pages, we will definitely accept less than the entire lease, because we do know it's a long lease. But also, as I mentioned, because every lease is different, we can't just say just the first 2 pages, because there might not be any information on the first 2 pages that we actually need. That might be on page 4, 5, and 6. But if someone has a problem uploading the entire document, they can give us what they think are the relevant pages, and the staff will let them know if they need anything else.
Okay, great. Thank you, Diane. All right, so we're down to our last question. This question, so if anybody else has one, get it into us now, as we'll soon be finishing up. So next question is, I follow all the steps and attach the notice of termination of lease. I return back to the court to file the motion for default judgment, and I was told to wait for a judge's response. Roberta, you answered this, at least typed an answer.
Yes.
Let's share with everybody verbally what your answer is.
And basically, I just said that then I would recommend he or this landlord file a motion for a hearing. So and he could go to the 9thcircuit.org, and usually the directions for each of the divisions is delineated in the JACS, which is the Judicial Calendaring Program. There's an electronic judicial calendaring program. If they don't have access to do that, I would say just come down to the Orange County Self-Help Center and or our civil division, and we do provide blank motions for you to tell the court what you need and why you need it. It's 2 questions.
So let me also add to that. Outside of the all of our civil judges' chambers are located outside room 370. And outside 370, we have hanging mail files. And what we typically would like, if there's an issue with someone getting a default judgment, you need to provide 1 copy for the court, for the original copy of the final judgment, proposed final judgment, and then a copy of each proposed final judgment for yourself, and 1 for each of the named defendants, along with self-addressed stamped envelopes. And if you put those in those hanging files, the judge's judicial assistant will get those. And if when we were reviewing all of our mail, when we're going through our mail, if we see something like that and we can't enter the final judgment, we on our own can then set that matter for a hearing. And that hearing would be conducted via Zoom or Microsoft Teams, whichever platform that judge is using. So there's really two ways to skin the cat. You can file the motion like Roberta suggested, or if you just want that default final judgment, you can file the paperwork and we could sign it if we feel after reviewing the case file, it's appropriate for entry of a final judgment. Pre-COVID, we would have what were called ex parte or short matters times, and landlords could come in during ex parte and hand the deputies all of that paperwork, and the judge would review it and sign it right then and there and issue the final judgments. Now, because of limited access and restricted access to the building, you're going to either have to do what Roberta said, which was file the motion, or bring us self-addressed stamped envelopes with the paperwork, and we would handle it in chambers and get it out as soon as we can, or set the matter for a hearing.
Okay, great. Thanks, Judge Dubois. So we have another question that has come in here. And this might be a question more appropriate for Diane to help answer. The question is, will there be any local funds allocated for those already evicted and living in hotels and motels without leases? Wonder if the rental assistance program that's already being offered would address that or not. Diane, can you help answer that?
So first, there are already funds that are going through the existing homeless system through the, they are doing a diversion and prevention through the homeless system. So that is already being done in many cases. There is funding that is going through those systems. So it would be part of the coordinated system of entry for the homeless system. In addition, we are also looking at the possibility of being able to move forward with providing some funds through the emergency rental assistance programs. It is one of the guidances related to some of the new guidance that came out from the treasuries, but we're evaluating those options and looking at what we'd be able to do. But there is money at this time from several other funds that do go through the homeless system that is able in many cases to assist with either hotels or rehousing for someone who wound up losing housing due to COVID. Some of those funds are also COVID related, but if that's why they lost their housing or are in a hotel, they might be able to assist through the coordinated entry system.
Okay, and how can people get connected with that? Who is that through?
So they can contact the coordinated entry system. They can contact the Coalition for the Homeless, has a diversion and a program that's able to assist. And there are several other of the homeless providers that are able to assist, and we'll get a contact information and share it.
Okay, very good. And a general number, if people have information or have questions and need information like this, of course, 311 is a resource that they can always call to try to figure out how they can get directed to specific resources.
Yes, so they can always call 311, which is Orange County's line, and they'll either transfer them through to emergency rental assistance if it's specific to that, or they'll try to provide an answer. And also 211, remember United Way's 211 is also a number that can be called for any type of social services, including shelter, housing, all of those type of things. And they'll refer to all of the agencies that might be able to provide that type of assistance.
Great, okay, thank you. All right, I think that wraps it up for us. We don't appear to have any other questions at this point. And I just want to thank everybody who's joined us tonight. Please don't run off though, because we have a short survey for you to take at the end of this webinar, and that helps give us feedback on future presentations, information you'd like to see. So thank you to the Orange County Sheriff's Office, to the Orange County Judiciary, to Orange County Government, to everybody who's been involved, all of our partners that have helped put on this webinar. Orange County Clerk of Courts, Tiffany Moore Russell, understands the importance of these conversations in our community. So that's why we provide these free legal forums to provide information and resources. We hope the topics discussed were helpful. And once posted, you may view this video at any time you'd like on our social media platforms. So and on our website, myorangeclerk.com. So check out our Facebook, Instagram, Twitter, LinkedIn pages to get the latest updates. And thank you for joining us. And as we mentioned at the beginning, there will be a short survey. Please take that survey. It helps us and we appreciate it to get feedback so we can plan for future forums like this for the community. Thank you for joining us. Have a good night.